Hi, this is Professor William Wagner, and this is a special edition of Faith and Freedom. What I want to do right now is spend some time reviewing what the Supreme Court of the United States has done recently. We saw a whole bunch of major cases just come out. And what matters is that the court is, in all these cases, returning the nation, returning the republic to a nation under the constitutional rule of law. And they're doing that by, in a way, advocating some of their power. They are going back to Article 3 of the Constitution that says that the courts in the United States are to decide cases and controversies. They're not supposed to change the meanings of constitutions. They're not supposed to add constitutional rights. They're not supposed to change statutes to conform to what their political preferences are. They're to take the law as they receive it. And that's the common theme of all the cases that have been coming down this most recently, but then, over this past year, really. And those who see the Constitution objectively through an inalienable worldview, like our founders did, we hold these truths to be self-evident. Generally believe that its provisions call judges in this republic, in our representative government, to act with restraint when they interpret the Constitution. They are to be limited by the constitutional provisions. They're not supposed to change them. And the judges that operate under this interpretive approach reflect a deference to the objective standards that the framers enshrined in the Constitution as the constitutional rule of law. So freedom of speech matters. The free exercise of religious conscience matters. Due process matters. These are limitations on the exercise of government power that are expressly in the Constitution, and they're not to be used to be manipulated and changed by some judicial pink ink in their pen, to conform to some politically preferred preference. And so the limited judicial review that these originalist justices take looks to the actual meaning of the text. Surprise, surprise. Let's say what the text means. And that same rule applies when interpreting a statute. What does the text actually mean? Because if the judge's role is just to resolve a case in controversy, and to resolve that case in controversy, they're to apply a rule of law, then it would make sense that they take the law as they get it. What do the words in the statute mean? What do the words in the Constitution mean? That's a very limited approach to judicial review. The court is just saying what the words mean, and then they resolve the case in controversy in front of it using that law. That's called the rule of law. Here, an inalienable liberty interest recognized by the framers generally receives a constitutional status as a fundamental inalienable right. That's our freedom of speech, the free exercise of our religious conscience, due process, things that limit the exercise of government power. Not included in that list would be things like abortion. And so about a year ago, when the court decided the Dobbs case, and we filed a brief, a couple of briefs in that case, when they decided the Dobbs case and overturned Roe, they weren't ruling on their preference for, abortion policy of one way or the other. What they were doing was they were saying, hey, our job as a justice is to say what the Constitution says and then resolve cases in front of us. Nothing in the Constitution, even pre-Roe or during Roe or after Roe, ever suggested in the Constitution that there was a right to kill an unborn child and that the government was going to bestow that right. Yet the justices in the Roe case, did just that. They made it up out of thin air and put it into the Constitution. And what the court did in the Dobbs case is what they're doing in these other cases that we've seen in this last year, and especially this last week. They are saying, our job is to take the law as we get it. And the Constitution as we got it did not have the right to kill an unborn child as a constitutional right, in the same way that there is a right to freedom of speech or the right to the free exercise of religious conscience. That is an objective constitutional jurisprudence. That's an objective constitutional legal philosophical approach to interpreting the Constitution, an approach that acknowledges and respects the rule of law, grounded in deeply rooted historical, cultural, and legal traditions, and in the plain meaning of the words as they were written when they were originally written. Compare that with an alienable world where you can make it up and you go along. The approach that many justices, like the justices in Roe and other places, rejected this inviolable, sacred standard, this idea that there was a rule of law that judges had to comply with, where the judges would reject it. And judges would utilize a malleable interpretive approach, a very alienable worldview. In other words, I can make it up as I go along, wrongly seeing the Constitution as an evolving organism, the meaning of which they believe that their office actually empowered them to actively manipulate. Well, folks, Article 5 of the Constitution provides two ways to amend the Constitution, and both of those ways involve the people and the states. Neither one of those ways in the Constitution, in Article 5, for changing the Constitution, says that judges get to do that. And so, for many years, that approach to interpreting the Constitution, in other words, if I have a robe on, I can decide what I want the Constitution to mean. It prevailed, and it prevailed in cases like Roe. It prevailed in cases that, like the Lemon test, that said, religious conscience doesn't matter anymore. You have to have a secular purpose for everything you do, or you're violating the Establishment Clause. Here, as my friend Professor Augusto Zimmerman correctly observed in an article he wrote, the goal of legal interpretation no longer becomes the search for absolute principles or objectives, but rather the search for the process that generates the right kind of change. In other words, I'm wearing a robe, and so I get to implement my political preferences by changing the Constitution, because I believe that that's good for, that kind of change is good for the nation, in my own personal view. Well, the problem with that is nobody elected you if you're on the federal bench, and nobody's going to hold you accountable for your decision like they would if you were in the elected branches of government, where you're actually representing the people, as opposed to just merely supposed to be deciding cases and controversy. And so the story behind the recent Supreme Court decisions is that a majority of the Supreme Court is now returning to the rule of law. And so I want to go through, some more of these cases. We just touched on Dobbs a little bit and how it overturned Roe and what was going on there. But let's talk about the First Amendment, for example. The First Amendment to the Constitution provides that Congress shall make no law respecting establishment of religion, prohibiting the free exercise thereof, or abridging the freedom of speech. Now, what leftists would do out there, and what they are doing, is they will, for example, go into a baker shop that's a religious Christian person, and that Christian person that owns that baker shop would never discriminate against a person based on who they are, would never discriminate against a person based on their sexual orientation, would make anybody a cake no matter who walked in the door. But what these leftists do is they come in and they specifically ask the baker or somebody that owns a shop, and they know that person has a Christian religious conscience, and they specifically ask them to do something they know would violate that conscience. Like, for example, participate in a religious ceremony like marriage of same-sex couples or something. That knowing that the person has a biblical view of marriage, that should be married one man to one woman, and they specifically then go and they ask them to do something that violates that conscience. And then when they don't do that, they go to the government and say, hey, these guys are discriminating against us. We want you to bring an action. And so when the government, like Colorado did and other places do, they bring an action against these people, then these cases end up, in the Supreme Court, and the individuals, the Christian people that are being, persecuted under these on these litigation, they then say, well, hey, court, the Constitution still has to matter. The government that's bringing this cause of action against me, they are limited by the Constitution. We would never discriminate against a person based on who they are. We serve anybody that comes in the door. But when somebody comes and asks us to specifically violate a sincerely held religious tenet, grounded in thousands of years of Christian doctrine, Judeo-Christian doctrine, we just cannot do that. And so the Supreme Court has held in the Masterpiece Cake Shop couple of cases, and they're still coming after this poor guy, Jack Phillips. But the Supreme Court has specifically held that the hostile lawmaking and hostile government actions interfering with religious liberty, they were previously found recently to violate the religious liberty protected by the First Amendment. Again, why? Because the court is now looking to what the words in the Constitution mean, and not interfering with the free exercise of religion is expressly in the Constitution, and they're not manipulating, those words to mean something else. And so in another case, and again, we filed briefs in almost all of these cases and have participated in these Supreme Court cases, trying to move the court to this very position where we ask the court to follow the constitutional rule of law, because we know that as Christian people, if they follow the law, everybody's going to be protected, including Christian people exercising their sincerely held religious conscience. And so in another case we participated in, 303 Creative versus Alinas, the Supreme Court just held last week that speech is also protected under the First Amendment. This is a 6-3 decision. Justice Gorsuch, joined by Justices Roberts and Alito and Thomas and Kavanaugh and Amy Coney Bryant, all of them said that this state law in Colorado compelling a person's expression, their speech, to celebrate same-sex marriage, infringed on the web designer's First Amendment speech liberty. Well, surprise, surprise, if you got the state of Colorado wielding the government power, the power of government, compelling a person to engage in speech to celebrate something that violates the sincerely held religious belief and doctrines, of the Christian faith, it's clear that the First Amendment protects that. But of course, they had to litigate this case all the way to the Supreme Court. Again, this is a Christian person who said she was willing to design, and clearly was willing to design, custom websites for anyone. Didn't matter who they were, didn't matter what their sexual orientation or how they identified was, as long as the message didn't conflict with her sincerely held religious conscience. In other words, she wouldn't, promote messages that, about abortion, about same-sex marriage. She wouldn't do anything that would allow, some kind of promoting of violence, or she wouldn't do anything that would promote, sexual immorality, for example. These are the kind of things, that would violate her sincerely held religious conscience. So when she chose to, exercise her freedom of expression, she was doing not based on anybody's identity or discrimination, but she was doing based on what her faith said about particular specific values and topics. And so that's very, very different than the allegations that you hear in the mainstream press, that this is just going to be a license to discriminate. And that's, of course, what some of the dissenting justices say. They ignore the rule of law, they ignore the constitutional rule of law, and go right to an emotional, oh, this is just going to allow for discrimination. When under the very facts of the case, the people involved, the people that are, the victims of this, litigation, and have had to defend themselves against these false claims of discrimination, clearly never have and never would discriminate against the person based on who they are. And so in that case, this is a 303 Creative, the speech case again, the Justice Gorsuch wrote in his decision, like many states, Colorado has a law forbidding businesses from engaging in discrimination when they sell goods and services to the public. Laws along these lines have done much to secure civil rights in America, and they have. And we agree with that. And I would say that the person who this law was used against would agree with that as well. Now, let me go on and see what Justice Gorsuch continues to write. He says, but in this particular case, Colorado does not seek to ensure the sale of goods or services on equal terms. It seeks to use the law to compel an individual to create speech she does not believe. The question we face is whether that course violates the free speech clause of the First Amendment. And in this case, the court found that it did, because the state was forcing an individual to speak in ways that aligned with its, political preferences, the views of the state, but defied her conscience, and the Constitution is clear. We have a constitutional right of the First Amendment, free exercise of religious conscience, and that is a limit on the exercise of government power. But government seems to, want to just ignore what the plain words of the Constitution say. And what is happening here in all these cases, again, is that the Supreme Court is returning to a jurisprudence, returning to a legal philosophical approach to the Constitution that is based on the rule of law, based on what the words actually say, based on what the constitutional law actually provides, and then deciding the case in front of it based on that law, as opposed to what they would prefer the law to be, and changing the law to conform to that preference in order to reach a conclusion. Do you see how this should be restoring integrity to the court, should be restoring legitimacy to the judicial branch of government? But very few people in the press, in fact, I have not found anyone in the press willing to cover this completely, and although there have been quite a few that have followed it accurately. But very few that are understanding the larger implications that what the court is doing is restoring legitimacy to the institution of the judiciary by saying, hey, we don't get to make this stuff up because we don't have to run for office. We don't get to make policy because we don't get held accountable by the voters every year. Our job is simply to decide the case in front of us based on what the constitutional or statutory law is. And here the constitutional rule of law was the First Amendment freedom of expression. And again, we had a few dissenting justices, again, relying on emotion and not accurately, I think, even reporting on the cases and basically saying the freedom of liberty and freedom of religious liberty and freedom of speech, should not be protected. Because it's a license to discriminate. Well, then change the Constitution if you don't think we should protect freedom of religion or freedom of religious conscience. And God help this nation if we ever go there. But certainly, just because a person is appointed for life and they get to wear a black robe, they're not the ones that get to do that, especially since they're not politically accountable to anybody and they never have to face an election. Another big question that arises when we're talking about freedom of speech is, what are we talking about? Because there are certain things that from the very beginning of this nation have never been considered speech because they're not speech. Things like obscenity, child pornography, incitement to immediate violence, slander, and libel. You don't get to slander somebody and then say, I've got a First Amendment right of free speech. True threats to do violence. For example, if you go into a bank robbery and you're saying, I've got a bomb and I'm gonna, unless you give me the money, and that's a kind of true threat that is not considered speech, and so it's not therefore protected by the First Amendment. But the leftists out there are trying to add something to that list of things that are not considered speech and therefore not protected by the First Amendment. They're trying to add this vague and ambiguous and arbitrary notion of hate speech, and they want to do it because it is vague, because it is arbitrary, and because it allows whoever is in power to use that vagueness to arbitrarily promote their political viewpoints by prosecuting people who disagree with those particular viewpoints. And so under the Constitution, therefore, the First Amendment says there is to be protection of freedom of speech. And the freedom of speech, it is a limitation on the exercise of government power. And that is, government must not regulate the content of speech. You can't regulate the viewpoint, or you can't regulate the topic of the speech. And that's what was happening in this case called Counterman versus Colorado. Additionally, due process requires at a minimum that the government provide notice of what is against the law. And so to comport with the Constitution, government must not regulate speech in a vague or overbroad way. And again, in that Counterman versus Colorado case, the United States Supreme Court came down with an opinion authored by Justice Kagan that it violates the First Amendment to prosecute an individual when you're making that prosecution and grounding that prosecution based on the effect of the words on the hearer. Now, can you imagine that? Michigan's got a proposed law right now that does exactly the same thing. And so instead of making it a crime based on what the person does, like a true threat, threatening somebody with real violence or inciting somebody to violence, they're saying that if somebody says something, and this was what the statute in Colorado did, if somebody says something, but the hearer perceives that as some kind of thing that is harmful or harassing or intimidating, whatever those words mean, now you've got a felony. On the other hand, if the hearer here's what the speaker says, and the speaker says something, and this time the hearer, the exact same words, the hearer says, wow, that's a very edifying thought. You have just really informed me on this issue. In fact, I'm going to change my mind on this issue. Okay, no felony now. Again, when you can base a prosecution based on what the hearer says as opposed to what the actual person is doing, now you've got a recipe for tyranny, because it can arbitrarily be enforced any way the prosecutor wants it to. So what was happening in Colorado was a law that kind of did just this. And what the court did then is the court returned to the plain meaning of the First Amendment and said, this is the First Amendment protects the freedom of speech. And so at the very least, if you're going to go after somebody for something they're saying, you got to have intent. You got to show the intent of the speaker, was to, do something that would be, unlawful. Like, and I talked about those things that weren't protected speech, for example, a true threat. So, did the court uphold the rule of law here? Absolutely. Did the court return the judiciary institution to a place where we're going to start looking at the rule of law? Yes. Let me read from the opinion. This is from the Colorado versus Counterman opinion. The First Amendment may still demand a mental state requirement shielding some true threats from liability. That is because bans on speech have the potential to chill or deter speech outside their boundaries. An important tool to prevent that outcome is to condition liability on the state's showing of a culpable mental state. In other words, if you're going to say somebody is doing a true threat, which isn't protected speech and should never be protected by the First Amendment, then just like every other crime, you've got to have an intent element. You've got to show that the person intended to be doing something that would amount to a threat, of actual, violence. And so very, very good decision for the rule of law. And that will affect the potential hate speech law that's before the Michigan legislature now, because under the Counterman decision, if Michigan's hate speech law is passed as currently written, it's going to violate the First Amendment. Right now, as that law is written, it talks about to frighten or intimidate. That doesn't, or the word harass, that doesn't equate with unlawful violence, and it's protected speech. So under Michigan's hate speech proposal, that proposed legislation, and it's been passed by the House of Representatives, that will potentially be used to prosecute anyone speaking on any of the cultural issues that that we're facing today. These issues that there's so much disagreement and the issues that divide our nation. Now you're going to get prosecuted if you participate in that marketplace of ideas and state your idea. If somebody feels like they're intimidated by you, as that law vaguely defines that word intimidate. If you speak for or against transgender issues, for or against religious beliefs, for or against some of these things, you could face a 5 years in prison, a $10,000 fine. So the category of intimidates another individual, unless we get rid of that, unless that's removed from the statute, anyone who is arguing some of these points on religious freedom or the political spectrum, they could face potential prosecution. And so, again, we need to understand that under the First Amendment, freedom of speech, government can't regulate speech based on the content or the viewpoint. And in addition to the vague way they've defined intimidate, allowing for arbitrary prosecution because of that vagueness, and putting and making it a crime based on what the listener or the hearer says, as opposed to what the intent of the speaker was. In addition to that, the law is, regulating speech based on its content or viewpoint, because the law specifically says, it has to be based on or pertaining to a person's sex or sexual identity or sexual gender identity or religion or any race or any of these other things. And because, the statute expressly lists this stuff, one of two things is going to make this law unconstitutional if it ever passes and becomes law. It's either a content-based regulation that is unlawful, because government can't regulate speech based on the content of the speech, the viewpoint, or the topic of the speech, or it's a vague and arbitrary law that will allow for arbitrary enforcement because of its extreme vagueness. And so, because Michigan law doesn't have an intent element, for the speaker, the prosecution based upon what the mental state of the listener or the hearer is, makes it unconstitutional. So I hope that I hope that the state legislatures of Michigan, who are politically accountable to the people, will read the opinion in the Counterman case and understand that what the court is doing is the court is saying the First Amendment still matters. The Constitution still matters as a rule of law. And we, the court, are going to start looking at it that way. And we're going to limit the exercise of our power. We're going to stop making up and changing parts of the Constitution we don't like. But at the same time, we're going to hold you accountable, governments and state governments who are politically accountable to the people and who also are accountable to the Constitution. You are limited to by the Constitutional's provisions, and the freedom of speech provision says that you can't, make up these new categories of hate speech and then say that it's not protected. Nobody's hating here. Nobody, but you can put that word on there, and if you vaguely word your law and then arbitrarily use that law against people that are different from your political perspective and then label them as a hater, you may make some political points, but you're destroying the legitimacy of a constitutional governance, and it's certainly not good governance, and it's certainly not governance based on the rule of law. Next case, you probably heard about the so-called affirmative action, or Harvard and University of North Carolina, and basically instead of using affirmative action, let's call it what the court recognized it as. It's preferential racial preference, and so what Harvard and UNC and many colleges were doing was giving preference in admissions, and they were considering race in that as part of that preference. Again, let's return to the Constitution. What does the Constitution say? Well, the 14th Amendment in part says no state may deny to any person within its jurisdiction the equal protection of the laws. So no state may deny to any person within its jurisdiction the equal protection of the laws. And so everybody's made in the image of God. Everybody has worth and dignity, and the government must treat each person under law that way. And when government acts and government uses its authority, they cannot, make things in a way that give preferences to one thing, one type of one person or a different person, because all are human beings, and under the 14th Amendment, we're all to be treated equally under the law. And so, as another justice many years ago in another case said, if you want to end race discrimination in this country, then stop discriminating based on race. And that's what many of these racial preference programs did, or affirmative action programs did. I'm going to read from the opinion here. Eliminating racial discrimination means eliminating all of it. Accordingly, the court has held that the Equal Protection Clause applies without regard to differences of race or color or nationality. It is universal in its application. For the guarantees of equal protection cannot mean one thing when applied to one individual and something else when applied to a person of another color. So what the court did here, again, was restore the constitutional rule of law as the rule of law for the nation. In other words, once again, what the court said, we're not going to look at the Equal Protection Clause and then say we would prefer it to mean that, well, it says we're supposed to be treated people equally. But if we find a political preference that we have where we don't want to treat some people equally, we're going to allow for that. And the court said that ends today. And so universities are no longer allowed to discriminate as they have been for the last many number of years based on race. And so again, the larger story not being told by the press is that the common thread through all of these cases is that the court is returning to a jurisprudence, returning to a legal philosophical approach to deciding constitutional cases by saying we first have to say what the law means, not what we want it to mean, and then we need to apply that law to decide the case in controversy. The next case is a postal worker case. And this time, instead of interpreting the Constitution, instead of saying what the words of the Constitution mean, the court was faced with asking a similar type of thing. But what does a statute mean? What do the words in a statute mean? And so, in addition to the First Amendment protection for religious liberty, Title VII of the United States Code requires employers to not discriminate based on religion and to accommodate a person's religious conscience. In the case of Greg Goff versus Lewis, the man involved here was a Christian, an evangelical. He had strong, sincerely held religious beliefs that he was to keep Sunday devoted to worshiping the living Lord and Savior and to rest. And so the United States Postal Service, nonetheless, punished this Christian man for exercising religious conscience. He, and the court noted, received progressive discipline for his not working on Sundays. Now, again, Title VII of the Civil Rights Act, 1964, because this case is being decided under this statute, not under the First Amendment, so let's not get it mixed up here. But under Title VII of the Civil Rights Act, 1964, it asserted that the United States Postal Service could have accommodated this Sunday practice, without undue hardship. Now that's what the government could have done. That's what the Postal Service could have done. They could have, accommodated his religious conscience, had him work on other days. This time it was a unanimous court held that Title VII requires an employer that denies a religious accommodation to show that the burden of getting that accommodation would result in a substantial increased cost to the conduct of its particular business. That's a big deal. That's right from the summary of the Supreme Court opinion. Now, again, let's go back to what the words of Title VII said. Title VII of the Civil Rights Act of 1964 makes it illegal for an employer, a covered employer, to fail or refuse to hire or to discharge any individual or to otherwise discriminate against any individual with respect to, things like compensation or, privileges of employment, etc., because of the individual's religion. Specifically says it's against the law to discriminate based on religion against your employee. And that's a statute, Title VII. Now, originally enacted, Title VII didn't specifically explain what it meant by discrimination because of religion. And Congress eventually, and I don't want to go deep in the weeds of why all this happened, but Congress eventually amended Title VII in 1972 to track some regulatory language that the EEOC had tried to clarify what it meant to not discriminate based on religion. And so the statute was amended to say that employers must reasonably accommodate an employee's prospective employee's religious observance or practice. Again, the statute was amended to specifically say that employers had to reasonably accommodate an employee's or a prospective employee's religious observance or practice. All right, unless that employer was unable to do so without undue hardship on the conduct of the employee's business. Well, you can imagine with that last little phrase there that courts who didn't like to protect religion and employers who didn't want to protect religion, they ignored it completely with the words without undue hardship. And they all kind of came to a position that, well, a de minimis cost was enough. That's going to be undue hardship if there's a de minimis cost. Well, the court said, you know what, just like in our constitutional interpretation, in our statutory interpretation, words matter. We have to say what they really mean. And the court came to the correct conclusion that more than a de minimis cost, is necessary to establish an undue hardship. And how did they do that? Well, to determine that what an employee had to prove to show a denial of religious accommodation, Title VII, the court started with Title VII's text. And that's, again, you go back to what the words mean. And the statutory term hardship, what does that mean? Well, something hard to bear if you look it up, and suggests something more severe than a mere burden. Title VII didn't say you just had to suffer a hardship. It said the employer, had to suffer undue hardship. And so when you add that modifier of undue, that means that that required burden, that required adversity must rise to some kind of excessive or unjustifiable level. So now when you look at what the words mean, undue hardship means something very different from a burden that means just de minimis. And that's what some of the lower courts and what some of the employers had just tried to get away with, because they didn't agree with the law. They didn't want to protect religious conscience. So they just made up stuff that was different than what the words actually said. And once again, what the court is doing here is returning the nation to a constitutional governance under the rule of law. And so that's where we are. We'll finish with the student loan forgiveness case. Again, Title IV of the Higher Education Act governed federal financial mechanisms, including school loans. The act authorizes the Secretary of Education to cancel or reduce loans in certain circumstances, very limited circumstances, by certain public servants, by borrowers who died or became permanently disabled, by borrowers that were bankrupt, by borrowers who school falsified certifications and closed down or refused to pay the lenders. Those are very specific things that the act authorized the Secretary of Education to cancel or reduce the loans. Well, the executive branch used that statutory authority and basically said, we're going to depart from those existing provisions and establish a student loan forgiveness program that canceled, $430 billion in debt principal, basically affected almost every borrower. And so the court said, wait a minute. Again, the constitutional rule of law matters. You can't exercise authority that you do not have. And here the statute says what your authority is. And the plain words of that authority do not include or allow you to go and make up, all this additional stuff that you would like it to say. That is for the people's representatives to do. And so, again, let me finish now by saying that there's a common thread that is flowing through all these cases over this last year or so. And that common thread is we're going to return to a constitutional governance that says A court should not change the Constitution. A court should not change a statute. A court should take the law as it gets it, and then under Article 3 of the Constitution, simply decide the case in controversy before it based on what the law is, not what the judge would prefer the law to be. And so I think for what it's worth, this is a good thing for the Constitution. It's a good thing for people of faith, because that means your expression and your religious expression and your religious conscience should be protected if the government uses its powers in ways that interferes with the clearly worded constitutional provisions that say, no, government, you cannot do that. So until next time, this has been Professor William Wagner, live from the campus of Spring Arbor University, for faith and for freedom. God bless you. See you next time.